M-SPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. M-SPAN, easy access to government matters.
He was counsel, first of all, because he was pro se, and now he's represented by counsel.
Yeah, I have a notice
My
of
counsel
appearance.
filed a notice of appearance.
I believe. Did they file notice of appearance?
I'm just trying to find
Pretty
it.
sure they did.
Okay.
If not, Your Honor, then we would
I would
proceed.
I would be fine with giving him like 30 minutes to read it. That's fine. I'm perfectly fine with that. But it just can't be. I think
I
we
don't
all
got
took the
30
time.
minutes, man. I got stuff to do today.
Your Honor, I
no,
don't
you
see
don't.
any.
No, you don't.
Okay, well, it does not matter if some people have stuff to do today. You guys are here now.
Your Honor, I don't see any written notice of appearance filed to the court by the plaintiff's alleged counsel.
I am checking that now, just to see if I But if there is none, then I'm afraid that appearance was not ended, so in that case you would still not be represented by counsel. I was under belief that there was, but I will double check to see if there is in fact one. Divine. I did add him to the case, did I? I hope I did.
Yeah, I was told, Your Honor,
Yes,
that
they
you
are
gave
added.
permission to appear.
Okay.
Price
Alright.
Vice.
Cases... Yeah, 1 second, please. It must be blind. I thought I saw it. We have defense, anyways, pro-hack vibe, and prog-vice. I did order them to enter and out of appearance. I believe. When was that? Yesterday sometime. No, not that one.
They were admitted pro hack BJ.
Yeah, but they need to enter an appearance. So I did give them permission to, of course, represent, but I need them to appear here. So if they're not,
Odd case.
told them at 2 in the morning. My time. Okay, so they haven't entered an appearance at all. They do have permission, so it's okay. So Bob, I am troubled. Your own attorney didn't do the final paperwork needed so they could actually represent you. They're not really representing you right now. Or they gave them permission to. They needed to actually put in the notice of appearance, otherwise I can't really recognize them. That's been a firm rule since day one, actually. So now it's up to you. I can give you time to read the brief if you want. They're happy with half an hour, or you know, if you feel so inadequate that you cannot make any representations whatsoever, and you think there is going to be genuine concern for your rights, and I will assess that, then I will need to know now, and I will need to know why you need to point out this particular facts that would show me that your rights would technically be violated if I were to proceed with this hearing today. So if you're happy with just reading the brief for half an hour, making arguments from there, that's fine. I have your papers, I've already read it, and I will be expecting to make full representations anyway if you were to go ahead today. So,
Well, Your Honor,
I have 2 options to it.
I'll plead my case for why I should be
Okay.
allowed to find another counsel.
No problem. You want
Your
another
Honor,
counsel?
Or well, wait for this counsel to appear or get another counsel.
No. So what I told you is that you don't have one right now. That's the
wait
weird part.
Wait for them to enter, I guess.
Your Honor,
Yeah, well, we can't wait, but
deadline-
hearing is today.
Your Honor, the deadline to enter notice of appearances for this hearing has expired.
Yes, so
Yeah,
I can allow them to appear.
If I could, he filed this case pro se, the complaint pro se, the application pro se. He stopped
Yes.
short of just reading the brief. So that's not really our fault. We shouldn't be penalized.
I'm not
having to show up
penalizing you
another
about
day.
this. I'm not. I'm just trying to make sure that you know, Bob, and I appreciate everyone having to make those statements. I understand where everyone's coming from with over on orangebear side. I do, but I want to make sure that Bob is also adequate legally to be able to represent his own case. And if he is, and I believe that he is in this current situation now, then I will give him the half an hour, as Effortless has mentioned he would allow.
Yeah, we're both.
And I don't think that's unreasonable. Okay, you're both allowed. Not unreasonable for me. And Bob, you did make your case so far. This is all you've pled to me. Your GRO, I have your complaint as well. I'm somewhat supplementing it. Not too much, but I am, considering both of these. But in the matter is the GRO that's going to be discussed. So that's all you've got for me. If you want to make more, I think today will be the time. Otherwise, if we do reschedule, you're going to absolutely need an attorney by that point. That's all I could really give you now. I have 2 options. You can read now and start.
I gotta go in about 30 minutes, but give me a couple minutes to. I already read over the brief.
You read over the brief. You'll be ready to make a representation.
Yeah, just give me a couple minutes because I didn't have anything prepared.
Okay.
Your Honor,
I
the court would
expected
suggest, sorry, Your Honor, defense would suggest a 5-minute recess to accommodate time for the plaintiff to prepare.
I'm happy with that. Let us do 5 minutes then. We'll go into a 5-minute recess. We'll reconvene at what time? 36. Is that okay for everyone?
Thank you, Your Honor.
Okay. Thank you.
Yes, Your Honor.
MSPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. MSPAN, easy access to government matters. MSPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. MSPAN, easy access to government matters.
Is able to make his own representations. He has appeared initially as a pro se litigant. He has agreed to continue as a pro se litigant during the proceedings. During these proceedings, at the time that there was a belief that he was supposed to be represented by counsel, that is to be divine crime of NUSA, unfortunately has failed to file a notice of appearance. We have double checked to make sure that we did not miss it. We cannot find any notice of appearance filed by them, and so the minute order scheduling this hearing requiring their appearance will be amended to not require their appearance, and that at this time they will not be recognized as counsel for anyone in part of these proceedings. Do we have any further questions? Otherwise, I'm happy to allow for Bob to begin. And I will limit the time for... Sorry? Yes?
Your Honor, can I add not feelings as counsel?
Oh my god.
It's very late now, I'm afraid. I'm sorry.
Okay.
If anyone has... If no one has any further questions, I'm happy to let Bob speak.
And says no further questions, Your Honor.
Okay, I will allow for approximately 20 to 30 minutes. I will be very limited in the amount of questions I have, and only responsive questions will be made. I won't raise any questions first to answer, since I need the whole case pled. So if that's fine with everyone, I will also look into the motion for summary judgment, and I will determine whether judgment should be reserved, or I will hand down a decision on the day of in this hearing. So just to let everyone know what I intend on doing. Alright, Bob, you can go ahead. You have about 20 or 30 minutes. I'll tell you what's going on. Take your time.
Alright, good afternoon, Your Honor. The opposing counsel is gonna try and argue this is, about me trying to tell the governor how to run the state. But, even when it involves the governor must comply with the constitutional guarantees of due process, especially before destroying someone's career, reputation, and livelihood. The due process sections of the Constitution and the 14th Amendment and the Federal Due Process Clause demand that before a state strips someone of their commission, security clearance, jobs, and authority, they need to be given an opportunity to be heard. That did not happen at all here. Now, before I go into the before I go into the federal standard under Winter v. NRDC, the defendants cited two cases, Orloff v. Willoughby and Egan. Both of those cases involved federal military and security determinations where Congress provided no review mechanism. In this instance, the governor's actions weren't as the result of a battlefield order or a national security judgment. They were They terminated my employment and revoked my commission without any statutory or constitutional due process provided to me. Even the Supreme Court in Cafeteria Workers v. McElroy recognized that due process protections may apply where removal, and I quote, forecloses one from all employment opportunities in their chosen field, end quote. I'll now move on to
Is that in reference to your law enforcement or your military commission or your security clearance points in your TRO application? When you reference that case, all three of them?
My security clearances are tied to my governmental positions.
Right, okay.
Alright.
Oh, sorry.
Now addressing the points on the federal standard for under Winter. On the likelihood to succeed on the merits, I have significant property interests in all of those. My commissions, my statutory, my Parks and Wildlife powers, and my employment are created under law, and they're not at-will privileges. The state has the judiciary overturned the at-will.
How is Sato going to talk about stopping crime when he's the criminal? He's a criminal. He's continuously getting arrested every other week for different crimes. And then we got Dave over here. What's about Dave barely plays.
Provided that. Alright, referring to my liberty interests, the removal under these circumstances, takes away my ability to effectively engage in my chosen profession, and that's covered under Paul v. Davis. And then no due process was provided at all. No, reiterating again, no notice, no hearing, no chance to respond. This is a textbook procedural due process violation, Your Honor. If this were to happen in any circumstance, the court would, grant this without a second thought. Moving on, irreparable harm. I've already lost my commission in the National Guard, and my access within the Parks and Wildlife Department has been taken already. My positions are unique that require my credentials and my commissions, and once they're lost, they're extremely hard to get back again. I was the chief counsel for the Parks and Wildlife. I mainly advised on policy and dictating whether it fell under state law. And within the National Guard, I was a member of the Judge Advocate General Corps as an auxiliary, which granted me my security clearance under there, and I was an infantry officer for the 2nd Air Cavalry Squadron. The kind of stigma that the governor's memorandums will always follow me in my career if it's not, overturned. They'll follow me. The state has very strict background check requirements. So these will obviously be reviewed, especially with the centralization of investigative power under the Bureau of Investigations. Courts have always recognized that the deprivation of constitutional rights in of itself is irreparable harm. I don't have that case law off the top of my head, but I'm sure I could find it in a supplemental brief, Your Honor.
It would be preferable, considering you are very deficient in the amount of case law you've cited, considering this is a rather important... These are very strong things you are, I guess, alleging, if you want to put it that way. And
yes, Your Honor.
a lot of good case law would be appreciated, so that it could be guided in how I could decide. And I have to do my own research as well, but yeah, I would appreciate that.
Alright, moving on to the next point, the balancing of the equities. The TRO is simply maintaining the status quo in this matter. I don't know why the government is essentially trying to force the court's hand due to the motion for a preliminary judgment, because they just want this to be over with. So the TRO would essentially be maintaining the status quo. And the governor and the government is not harmed by me continuing my assignments temporarily, while I am being gravely harmed. I'm losing my access to my paychecks, Your Honor, by not being able to carry out my positions without a due process. The equities favor preventing unconstitutional action, especially where reinstatement now avoids the permanent career injury. And moving on, the last thing, the public interest. The public generally benefits from government accountability, and the assurance that even the highest elected officials, follow the Constitution, Your Honor. Upholding the due process in this case, in sensitive roles, strengthens, not weakens, as the opposing counsel is going to argue, the trust in law enforcement, the military, and the executive branch. Now addressing some of the specific case law that the opposing counsel cited. Orloff involved a federal draftee challenging his assignment in the Army during wartime, with active service ongoing. He was actively serving in a war. It's not a state National Guardsman officer alleging a violation of constitutional due process and a peacetime removal. Orloff itself acknowledged that courts can review whether lawful procedures were followed in the appointment and removal. It just simply declined to substitute judgments on assignments. Moat concerned whether someone was an officer under federal pay law, not whether procedural safeguards applied before removal from a state commission. The Mayflower Constitution and its statutes therein give the commission their legal foundation, and once confirmed, they are state-created property interests protected by due process. This is established in Board of Regents v. Roth.
A property interest?
Yes, Your Honor.
That's pretty
My
strong.
positions held are property interests, Your Honor.
Yeah, okay.
I'm not asking this court to dictate the policy of national security. I'm only asking that the court ensures the governor follows the constitutional procedures, when ending my careers. And quite frankly, Your Honor, this is a political move to attack me. Moving on to Department of the Navy v. Egan. Something I studied a lot when I was in the Judge Advocate General's Corps. Egan was about the Federal Merit System Protection Board reviewing a Navy clearance revocation, and Congress did not grant that review. I'm not challenging the merits of the clearance decision, but the lack of procedural due process under the governor's order, like Egan did. So, reiterating, Egan challenged the merits and not the due process. He had due process in his procedural revocation. Going back to cafeteria workers, it supports my position. It recognizes that due process may apply when exclusion from employment, quote, forecloses the worker's freedom to take advantage of other employment opportunities. By revoking my security clearance, that's exactly what they're doing. It's very hard for me to get a job in any position that requires a security clearance, especially in my chosen legal field for the government. The revocation of the clearance, coupled with all the removals from my positions, essentially blocked my career. Moving on, referring to SNEP. Sorry, hold on, my notes are a little messy.
Take your time. I am aware of the time. I could overlap. So,
Alright,
do mind it.
SNEP concerned the enforcement of a secrecy agreement and equitable remedies for breach. It didn't involve the wholesale deprivation of multiple positions without hearing. And even if, as the government argues under Egan, that the clearance determination is discretionary, the consequences imposed here, the loss of all my positions, they do trigger due process protections. To one of their points, paraphrasing here, they argued that the courts can't enjoin an executive from removing a subordinate or reinstating someone. The cases that they cited concern permanent equitable relief and the scope of removal of power, not temporary relief to preserve the status quo pending adjudication, as I'm trying to do here, Your Honor. Referencing White, White predates the modern due process framework established in Loudermill v. Roth. So I don't believe that should be heard. And the courts have time and time again enjoined removals or suspensions that violate due process protections. Gilbert v. Homer. Myers and Humphreys were high-level federal officers and structural. Hold on.
Bob, I'm
And
aware
they
of
were-
the time. I'd like you to maybe not have to tell me to hold on every time you look at your notes. Well, I do appreciate that you're in a rather difficult position, but preparation is essential. You did have a whole date in case something was going to go wrong. So, please.
Myers v. Humphreys were about, high-level executive positions, which had, how do I phrase this? They had a lot of decision-making authority. Referencing my job in the National Guard, I was just, an infantry officer. I was the first base rank commission. I didn't have any authority over planning large-scale operations and all this stuff. I was told stuff like the day of a large exercise. Even with the separation of powers as they cite, the court's role in this matter is to determine the executive actions are compliant with the constitutional limits. As they're going to try and argue, granting a TRO in this instance, it's not going to retain anyone. It just pauses enforcement until the merits are decided. There's no damage to the government.
So I'm a little confused because wouldn't the result of me granting that TRO in that case would be to essentially reverse everything that's ever happened to you just now from those memorandums and potentially reinstate you back into all your positions?
Yes, Your Honor, but the point I've been trying to establish is that my positions weren't in any state, high-level state positions, as they use their case law to cite.
Right.
That's what I've been trying to point out. That's really all I have to say on this, Your Honor.
Oh, okay.
Thank you.
Okay. That's all. That's your entire case.
Yeah, I can respond to questions if I need to.
Okay. If I have any at the end, sure. I'm gonna try and make sure that everyone gets their case heard at the very least. Well, since you said that was your case, I'm happy with that. Bob, sorry, not Bob. Mr. Britt and Mr. Sado.
Sado and Pacto will make oral arguments for the defense, Your Honor.
Yeah. Is it gonna be the opening or the oral arguments?
The opening, Your Honor.
Oh, sorry. Okay.
Sorry.
So, Sado, go ahead. I'll hear you by remote means.
Yeah, just 1 second. I gotta adjust my volume.
Oh, that's fine.
Do we have Sado over a Zoom call?
He is. We have him on. We have him on our screens.
Alright, I'm here. Yeah, if you point to the monitor in the back corner, I'll be appearing virtually.
Wait. Oh, that's your word. Oh, that's amazing. Put him in the corner, Luso.
Sado, you can go ahead and make a statement.
Next to Mr. Bob over there.
Alright, go ahead.
I'll begin. We are going to, well, me and Mr. Britt will be splitting this about 10 and 10. I think you said it's about 30 minutes, 20 minutes, right?
20 or 30 minutes. I'm going to give everyone around that time. Yes.
Okay, so we'll split it 10 and 10. Just to reorient us, there was 3 memorandums issued. The first one suspended his operational law enforcement authority. It removed him from his positions in the Department of Parks and Wildlife, and not the CCSO. It just revoked his specific law enforcement authority. The second memorandum, his commission was withdrawn from the Mayflower National Guard, and the third memorandum, his security clearance and his access to classified information was rescinded. That's just to reorient us, and I will begin with our opening statement in opposition to the TRO. So this is the governor's opposition.
One moment before we even begin with that, I just want to clarify whether with Bob on his CCSO situation, if you don't mind. It's gonna take like 10 seconds. Is that okay?
What do you need to clarify?
So Bob, you will make a truthful statement here, okay?
Mm-hmm.
You swear that you do, and that if you do lie, it's gonna be very bad for you. You understand that?
I understand how perjury works, Your Honor.
So, what was your capacity in CCSO specifically?
Well, I kind of served 2 capacities. Oh god, Rami's right next to me. So I was the chief counsel prior to my district attorney position, so I've kind of retained that. And then I was a corrections officer, Your Honor. And then pertaining to Parks and Wildlife, yes, Your Honor. And then pertaining to Parks and Wildlife, I was their legal head as well as the chief parking enforcement officer, essentially, which I've been stripped of that now.
Were you at any point a commissioned peace officer of the state? In any
No, Your Honor.
capacity? No, okay, thank you. Alright, go ahead, Sato.
Alright, I'll start once again. May it please the court. This is the governor's opposition to the plaintiff's application for a temporary restraining order. And this will also be a little presentation in support of our pending motion for summary judgment.
Okay.
On its face, the application fails at the threshold, and on each of Winter's factors. Two of the three, I should actually say all of the three factors that he's raising, that being collateral challenges to the memorandums, but I'll get into those individually, are non-justicable as a matter of law. The third turns on an asserted property interest statutes do not create. The Mayflower Code confirms the Attorney General's supervisory authority is relevant here, and the statutory authority over clearances is likewise vested in the executive. Plaintiff cites essentially no supporting authority in his TRO papers. First, the security clearance claim is non-justicable. As the United States Supreme Court explained, as the plaintiff himself brought up, in Department of the Navy versus Egan, security clearance decisions, both granting and revoking, are substantially, through case law, committed solely to the executive. And this is, I'm quoting, because they are sensitive and inherently discretionary judgment calls. The court in that same case also held that no one has a right to a security clearance. And as I'm sure many of us are well aware, due process only flows from things that are naturally, let me backtrack. Property interests are only conferred based on the rules and understandings that govern said interests. So there has never been an understood right to a security clearance. Furthermore, the executive's authority to classify and control access flows primarily from Article 5, and of course, the case law that we look at looks at the analogous Article 2 on the federal level. In our state's analog vests the executive power and command functions, that being the commander-in-chief authority, in the governor, and by extension, the adjutant general. State statutes also authorize the issuance and revocation of clearances through the Attorney General, so it's essentially just committed solely to the Attorney General and the governor. So if I can actually read the statute, let's pull this up here. For MSC 3, Section 1401, the authority to classify information, it's blurry on my screen, but it includes the governor in subsection A. And then in 4 MSC 3, Section 1501, it goes through that the Department of Justice, through the Attorney General, shall have the authority to issue, revoke, and regulate security clearances within the state of Mayflower.
Is this your opening statement or is this your case?
This is our opposition, both our opposition to the TRO and also our little presentation.
I guess that. But are you making an opening statement, or are you making your full submissions here now? Because this sounds more like you making a case.
This essentially goes to his likelihood of success on the merits.
No, I get that, but are you making an opening statement as you were supposed to do, or are you making the case and Britt doesn't get to speak? Like, I don't get what's going on here. Because he told me that you were just going to make the opening statement, which is. Well, I had to assume.
I would assume I'm making the opening statement, but yeah, this is essentially going to one of the prongs of the TRO, which would be he does not have a likelihood of success on the merits.
Okay, I think that's fine. I do apologize, but it sounded more like you're making the case when I thought Britt was going to be doing that, so it just felt a little disorganized.
No, that's okay.
To put it that way. Yeah. Please, sorry, I didn't mean to stop you. Go ahead.
So to the second memorandum, that being the commission withdrawal, that claim is also non-justicable. And this was brought up, he said something like, the plaintiff said something along the lines of, it only applies federally. And, well, the thing at hand here is that the governor has essentially, he delegates his military authority by the Constitution to the Adjutant General. However, the Adjutant General is constitutionally obliged, and the phrasing is actually shall carry out the orders of the governor. So it's essentially, it's literally just, it's like two people in one god over the military. And continuing on, the commissioning and removal of military officers is an exclusively executive matter over which the courts should have no control. And that's directly from the Supreme Court in Orloff versus Willoughby, which I will note that the plaintiff substantially mischaracterized, and I will give the actual full characterization. And the quote that deserves the most attention is that judges are not given the task of running the army. An officer status turns on an executive commission, and absent a commission, one is not an officer. The Mayflower Constitution mirrors that allocation, that being that the governor commands the National Guard, and the Adjutant General, as I stated earlier, must act in complete conformity with the governor's instructions. And courts will routinely avoid intrusion into military affairs. And that's quoting from Egan, and you also can look back to Gilligan in, that was a case where they tried to get an injunction to surveil the military, the National Guard, but that was overturned by the Supreme Court. And third, the law enforcement authority claim fails because on the merits, because there is no protected property interest in powers that are essentially not his, but rather delegated from the sovereign. Property interests arise only where state law creates a legitimate claim of entitlement and an expectation. Mayflower law centralizes statewide law enforcement supervision in the Attorney General and authorizes audits, directives, revocations, and reassignment. The challenge memorandum directed the Attorney General to withdraw the plaintiff's delegated arrest and special commission authorities. Delegations of investigative authority are not private entitlements. Without a cognizable property or liberty interest, he's essentially not doing any process at all. And I might also emphasize separately that there must be no right conferred in any way at the end of this case, because for this court to essentially audit, this court would essentially be auditing the military's appointments, wherein when I said non-justicable earlier, I stopped short of saying the doctrine that actually precludes that being the political question doctrine, which is the primary basis for judicial abstention, because the supervision of the military is textually conferred only to the executive branch and obviously the legislative branch to regulate the military as they see fit. And as I've explained extensively, both as a presentation to our motion for summary judgment, and now I turn to the other factors of the TRO, that being irreparable harm and the balance of equities and the public interest. And the last three and four factors merge because the government is a defendant here. The plaintiff cannot show irreparable harm, as I've explained, because job reassignment, well, at its threshold, job reassignment and loss of delegated powers are not irreparable injuries as a matter of law. And that goes all the way back to Sampson versus Murray in 1974. And reputational allegations alone do not establish a liberty interest deprivation without an accompanying change in legal status. Alleged economic harms are likewise not irreparable. Loss of political officer official power is also not a cognizable private injury. The basis for all of this is that he is trying to essentially assert a private property interest in power that was delegated to him by the sovereign, which, as we are all well aware, those are committed to the executive, and he is essentially trying to reclaim the executive's power. Third, as to the third and fourth prongs, I should say, the balance of equities favors the state, and the governor's duty is to take care that the laws be faithfully executed. To the Attorney General's enforcement power, he is the chief law enforcement officer of the state. He is empowered to regulate, direct, and correct agencies and officers. Judicial interference in real-time executive supervision risks substantial harms to public safety and institutional integrity. And the equities would not and, frankly, would never favor reinstating an individual to sensitive posts. And I conclude here by mentioning that the public interest weighs strongly against the TRO, as not only do the courts afford the utmost deference to executive responsibilities in national security and military matters that goes all the way back to the United States versus Nixon, Haig versus Agee, and clearance decisions are likewise not justicable. And then in closing, equitable relief against the governor's core executive acts is unavailable. And courts routinely refuse to restrain executive officers from, even in the case where it's a wrongful removal, they frequently refuse to restrain the officers because in cases where a removal is challenged, those cases are usually, the relief sought is not reinstatement. It is either back pay or some kind of wages not paid. It is never reinstatement, and those traditional the traditional equitable remedies at the founding of both this country and by extension the state did not include injunctions compelling reinstatement of executive officers. And as the Supreme Court recently reemphasized, this is a very recent case, as President Trump has been dismissing a lot of executive officers at will. In Dellinger versus Besant, the Supreme Court essentially reemphasized what I said, where reinstatement should not be a remedy because it was not seen as such at the founding of this nation. And the same limitation applies here. And I believe that is all I have to present at this time.
Okay. I'm not sure if you... We can get an opportunity to respond, but they haven't... I believe they haven't finished the full submissions yet.
I believe it's just...
And I'd like to hear it.
A few things left, Your Honor. I'm just quickly catching up to where... Sorry.
Right. No, because I just wanted to ask, and I don't know if you want Seda to answer it or if you want to answer this, but it's mainly about Stigma Plus. At the very least, if there is any concern for Stigma Plus and any liberty interest concerns to be raised, because the memorandums were public as well, and they have,
if I could address this, I think we did cite a quote from Egan where it said, specifically as it goes to the revocation of national security clearances, the revocation of a security clearance does not impute disloyalty or any negative characteristics on somebody. So that's a direct quote from that case, and I'll turn it back over to Britt.
I would, Your Honor, I would only kind of reinforce what Seda has just said in the regards that when we review the memorandums, although yes, they are public, and that would be in the same sense that department logs would be public, what we would need to look for when considering matters such as Stigma Plus is what kind of language is being used within the dismissal itself. So, for example, if we were to look at the withdrawal of commission and the dismissal, at no point is there any negative language used or any language which would impede on the plaintiff pursuing a future career in any field, and similar applies to the law enforcement memorandum. No negative language is used which would imply a stigma plus or any form of property interest or liberty interest, which obviously is what you're describing and alluding to. There are a few things I wanted to address. Firstly, I did just want to address state security clearance. I know that the plaintiff mentioned within his hearing, within his arguments, that his inability to gain state security clearance would massively impede his career, and it was on this basis in which he tried to claim a right to due process, essentially claiming a property interest. I would direct the court to the memorandum and the wording of the memorandum. Although it does rescind the current clearance of the plaintiff, at no point does it prevent retrospectively the plaintiff gaining clearance in the future. There is no blacklist in a sense, of the plaintiff being able to claim clearance in a future position. So I would just want to stress that to the court, because I think that argument was played quite a lot by the plaintiff and it holds no real backing at all. So I will just quickly get up to where we were within the from Sado. I think there were just a few last bits that we wanted to address. So I know we talked about that.
And after that, of course, I'm going to make it aware that Bob will be given an opportunity to respond as well.
Of course.
From that point onwards, I'm going to limit to only one response of a very short amount of time for both sides.
So if we just, okay, so we're just going to quickly, I believe we're just going to quickly discuss these last few bits. So I know security clearance was already discussed, and I think Sado did already touch on this. But the plaintiff's security clearance fails the merits for independent reasons. The court is unable to re-weigh classified access determinations under preponderance standard, which is clearly consistent with the interests of national security, in which we see an assertion within the memorandum. So that standard will clearly indicate that security clearance determinations should err, if they must, on the side of denials. Essentially, Egan here is reaffirming our need to be precautious, and also the courts need to take national security as a factor into account, and when potentially considering reweighing, erring on the side of not doing so. So essentially, oh yeah, sorry, and Spam wants me to go to the stand, I apologise. Essentially, if the court were to introduce judicial review, it would essentially second guess the agencies. So in this case, it's more regarding the executive, but their national security determinations, which would not only undermine the national security of the state, but would also, in a sense, undermine the decision of the people to democratically elect their individuals to make national security determinations on their behalf. The Supreme Court has long recognised a compelling government interest in protecting national security information from unauthorised disclosure, as we see in SNEP in the United States and Reynolds, Totten and United States, just for a few examples. And the reason which I'm stressing this, Your Honour, is the language which is used in the memorandum, which makes it very clear that this rescindment is on that basis, is surrounding that basis. However, just linking that back in as if not to imply a stigma plus, there is no negative connotations within the revocation of security clearance, but that was more just discussing judicial review, as I don't believe that was necessarily touched on.
Okay. I guess it's not really an off-topic question, but I do want to get maybe some clarity. When it comes to reviewing security clearances of particular individuals, is there like a particular process that the government uses? Is it like a hearing, or is it like a notice of like why the security clearance is likely being revoked, or is it all anonymous, or who does a review, or stuff like that? Is that something that the court is privy to know about right now, or do we need to maybe hear that, in a closed setting? I just kind of want to know that information, just so I could explore whether there is any particular due process concerns that Bob has raised.
I think ultimately
I can answer this question if you don't know.
Yeah, no, go ahead. I'm not. I don't want to interrupt. All I would say, and I will let Sado answer the bulk of this because he is a lot more well-rounded on the security clearances portion of this argument. The only thing that would come to my mind would be obviously maintaining the public reputation of the individual, and ensuring that there is no stigma plus. Not saying that necessarily if there was a public disclosure that would be the case, but obviously respecting the individual's right to privacy. If such a disclosure was made, I think we would want that to be of any private hearing. But I will let Sado answer in regards to the right of judicial review and the access of which they would be granted.
Sado will be answering this remotely. Go ahead.
Okay. Yeah, so as it goes to security clearances, and I've said this multiple times already throughout the hearing, they are essentially entrusted solely to the executive's discretion, that being the governor and by extension the adjutant general, who are both empowered by statute to not only classify information, but the governor can also be petitioned through the Attorney General to revoke someone's security clearance. So the statutes do not provide any process. And in essence, as I've repeated again from Egan, nobody has a right to a security clearance. It's a delegated power from the sovereign that nobody has a private property interest in. This is actually straight from Egan, where they said he did not have a property interest in a security clearance, even if it affected his job, because it's from the executive and he's not privately entitled to it.
So, frankly, there is no interest. Is it fair to say that there is no interest in
no
a security clearance whatsoever?
Your Honor, if I may,
Yes.
there is only two more. Well, essentially one more and then a short conclusion just regarding the due process and its non-judiciability.
I'm aware of the time, so you
Yeah, this will be very, very brief, Your Honor. So, essentially this is just regarding Orloff once again and the wide discretion which is granted to the executive. So we did hear from the plaintiff an attempt of a due process claim in order to avoid non-judiciability. As we see within Orloff at 90 to 94 of 340 US, the commander-in-chief, in this case the governor, under Article 3 must maintain a wide latitude, so a wide margin of discretion in regards to personnel and assignments. As Sado has already mentioned, we see the alignment with our state constitution and the federal constitution making this precedent relevant. And I just wanted to kind of reaffirm that to the courts as we kind of come to our closing. So, in summary, the plaintiff cannot show likelihood of success, irreparable harm, favourable equities, or public interest supporting relief. Two of the claims, although it could be argued the third claim, as Sado did also, are non-justiciable. Although if we were to attempt to argue a protected property or liberty interest in regards to due process for the third claim, that would ultimately fail for the reasons of which I stated in regards to there being a lack of stigma plus. The request. Oh,
sorry. No, go ahead.
I was just going to say the requested injunction will contravene the separation of power limits on equitable relief. There is a lack of supporting authority by the plaintiff to attempt to dismiss this argument by the defence, although he did address it within his oral argument, albeit briefly. He was lacking in any substantive authority to distinguish our claim. As a result, we respectfully request that the court deny interim relief and would set a schedule to resolve the case in existing briefing. I know Sado would like to quickly discuss, only for 30 seconds, Your Honour, stigma plus, just to clarify the issue in that regard, just so the court is aware, in case any due process arguments are entertained. Thank you, Your
That's
Honour.
fine. I'm happy to do that.
Yeah, so as we've already
30
addressed, there's two due process concerns, one property, one stigma plus. Property interest we've already all set aside.
Yes.
Stigma plus, Roth on a facial reading is not essentially absolute anymore. It's been abrogated recently by circuit courts, where they essentially say that the charge must be false. It must be false. So it has to stem, not only, it has to cause reputational damage, but also it has to be false. That's what I have to say to that.
Okay. Sorry, that's fine. Thank you.
Thank you,
If there's of course, if there's no any further comments, then I'll let Bob respond. I hope I gave him a little bit of, material, and possibly some answers if he had any questions that he wanted to maybe ask. Yes, please.
Alright, I'll start with the National Guard. Something that was not in my brief, but I feel I should bring up now. I wasn't just removed of my security clearances, I was completely relieved from service in the National Guard. Pay grade is, I do have a vested property interest because it's my source of income. My pay grade, which is established through rank.
But you're not making
you're
not wanting to get back pay or anything, are you?
I don't believe so. I'm getting back pay or anything.
Right. Okay.
The the defense is completely mischaracterizing Egan. In Egan, he was challenging the merits of his removal from his security clearance. So he's effectively saying, hey, I was removed from my security clearance for the wrong reasons, and that's why he was challenging it. He was not challenging the due process, which he was provided with regards to his security clearance. And I further cite again cafeteria workers. They also stated executive offices in regards to the Trump administration. But, Your Honor, in all of these positions, I was not in an executive office in a decision-making capacity, as they would like to argue. In regards to the law enforcement powers memorandum,
Did they argue that?
I believe
Did
they
you guys
did.
argue? They did? I don't.
We did.
recall that.
We essentially just said it's an assignment of powers within the executive branch. It should not be reviewed.
Right, my misunderstanding.
Your Honor, with regards to that, I believe that's completely untrue. In PAW and CCSL, those powers are the job, and in Gilbert v. Homar, the holding was a police officer suspended without pay after being stripped of badge, gun, and their duties was entitled to due process protections, even though they were technically not fired. I'm also reiterating, I was fired from the National Guard. It's not like I was just taking my security clearance and not given assignment.
Right.
So that's in Gilbert v. Homar, Your Honor.
Okay.
So
is that it? Oh.
And I have kind of one more point to overarch this. I'm not
Very
arguing that I'm not arguing that the government doesn't have a right to determine who does and who does not get a security clearance. But in Cafeteria Workers v. McElroy, the due process protections may apply where removal, specifically, removal, as I was from the National Guard, forecloses one from all employment opportunities in their chosen field. So that applies to both PAW and the National Guard. That's it. I'm open to questions, Your Honor.
Well, I don't really have any particular questions at this rate. Not that I really had a lot to ask in the first place. I generally have an idea what I might want to do, but we called this hearing because you had such a deficient application and complaint that I thought it would be good for you to at least present or elaborate more of these issues that you raise in an open court setting. Anyway, any response to that, Britt, Sato? No? Yes?
If Britt, do you have anything to say?
I mean, if it's to clarify something, I don't need that. If it's to bring up some new point or just kind of get the court focused back on what your point is, and that's fine. But other than that, I'm not going to allow a response unless it's one of those two reasons.
I'll let Sato speak for the defense, Your Honor.
Okay. Sato?
I don't think of anything else to add, honestly. It's just, you know, he doesn't have a property interest. Liberty is really the only one remaining, so that's all I have. Oh, also, I should probably just a little rebuttal. The only reason he was given process, well, in Egan, actually what happened was he appealed his revocation to the MPSB, Emeritus and Productions Board, MSPP. And that was because he was specifically given statutory appellate ability. We don't have that here. It's essentially just it's a very textual
right of appeal.
You don't have a right of appeal. It's a very textual, and actually, if he really
no, I mean like what you meant, appellate ability. That's a little.
Yeah, I'm kind of afraid that weird. I'm a little brain dead right now. But what I was trying to say is there's no administrative review. It's just the governor doesn't want it. It's gone. The commissioner doesn't want it's gone.
Okay, I got that.
But yeah, that's all I have to say.
Okay. If that's all, then I think we'll reserve judgment. Clearly, I think it'll be good if I at least took maybe a day to not only think but also draft my decision. Deciding whether to announce an open court, I'm not sure. It's not really usual after a TRO like this, but because it's potentially or likely very significantly important, as with any case related to someone who is a district attorney, an elected official. I'll determine that obviously your appearances will be required if I do require you all to appear. But otherwise, I think I'll reserve judgment. I'll think about this, take a day or two, come up with something, and then you all get to know what happens. In that case, if there's any time constraint involved that I could control, I will enter an order that will allow us to reset or somewhat pause these proceedings for the time being so that we could not overlap with any time constraining issues under the rules. If I were to make a decision, I think one of three things could happen. It's either that the trial gets denied and summary judgment denied and thus case dismissed, not thus and case dismissed, or I do grant TRO and summary judgment denied likely and case will proceed, or I will allow or deny the TRO and give maybe a partial grant or denial of summary judgment, and the case may proceed in that situation only as to the ones that I've granted. Those are the kind of three things that could potentially happen. I am aware that this is not an emergency matter, so I will not need to make a decision in like 12 hours or 2 minutes, thankfully. So if anyone needs to plead something that is very urgent, it has to be a genuine emergency, otherwise I will not bother. So that will be appreciated. As to the case channel, no crosstalks please. It has become a massive problem, especially mine. I cannot keep track of what's going on with the cases. I appreciate that everyone's trying to make their case, but there is a time and place for this to happen. There is an opportunity for people to make their cases, and the time to do it. If that could not be adhered to, then frankly, I think we're all wasting our time. So please, can we get a little bit of respect for submissions? Opening statements should be only for opening statements. The actual case should be presented when it is time, and I tell you to do so. Closing arguments, all that stuff, all should be done in the appropriate time, and should be what they are. I appreciate Sato making the opening statement, but it felt more like a case presented, if anything, so I got very confused. Do not mind me if I ask questions about that. I am trying to follow along. It was a little odd, but that's fine. That's all I would also
recommend reading the brief back.
I already read the papers I have, and I understand that Bob is unfortunately was unable to represent. But I thought they would. I thought a notice was entered, and that's why I made an order for them to appear. But apparently that was not the case, and so
I was under that impression too, Your Honor.
I was too, but unfortunately that was not the case. I do really apologize for that. As I will have to see what's going on with Divine, because that was very inappropriate of them for them to file all that and then not do the last paperwork they need to get in and actually appear. I did tell them to appear, but unfortunately they didn't, and there's very little I could do in that regard. I'm not really the kind of guy to compel people to appear just like that. I don't even know where they are at the moment. So, but I will keep everything in mind with your situation, Bob, for today.
Thank you, Your Honor.
Please don't, of course, please don't mind that. If you wish to seek representation, if you wish to seek an attorney, you can go do that. You have the time to do it now, until the next hearing, essentially, if there is any. If you want to get that in, preferably by today or tomorrow, I'm happy to allow that, or whenever. I will just need to know the name of that person who's going to represent you, and I need them to file the paperwork. That's all I could suggest. Otherwise, I'm happy to adjourn here, and we can convene at some other time, or you can hear back from me remote. Yes.
I don't have another argument to add, but it's just one final
That's
little
it.
caveat
100%.
to add.
that is, if you do grant the TRO, just be cautious of ordering something like a hearing, because if this case is, in the future resolved in our favor, we can't hold a hearing. So just be cautious of that.
Obviously not. Yes, I am aware of that, and as to the remedies that could be resulted from this as well, that could be granted as well. I'm also aware of that, and I have to be very careful of that as well. So I will.
Yeah,
of course,
just not giving effect to final judgment.
Well, we'll have to see if it is even possible in the first place. So we will. I will do my homework on this as well and make a decision as soon as possible. Otherwise, I think we'll conclude it here, everyone. We'll
Thank you, Your
adjourn,
Honor.
where judgment is reserved until until a preliminary time of 8:30 in Eastern Standard Time on the 15th of August. This may change depending on how busy I am. I do apologize. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Close adjourned.
MSPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. MSPAN, easy access to government matters.